Okay, so Vinnie, you've heard why we're pursuing immunity legislation, and it's because we don't have that insurance coverage that would protect us from those kinds of claims. So tell us where we stand with insurance coverages these days.
Well, thank you, George, and thanks, Dave, for the lead-in. I will say to start, one of the positives from this experience, from the Zoom and from working from home, is the occasional treasure hunt you have to go on for things like today, like going to find pants or a sport jacket, or even a sport jacket that fits, is always a little treat that we get to enjoy once in a while. So thank you for that today. Let's talk about the insurance coverages and what are some of the hurdles that we're seeing from the carriers to respond to these COVID-19 claims. And hurdles, by hurdles, I mean exclusions and policy language. So first, let's look at the general liability. So general liability is going to cover typically your bodily injury and third-party property damage claims. Somebody that slips and falls on the property, gets injured or catches COVID, or that some property damage, some third-party property damage happens. These are what's called occurrence policies. All right, they're date certain. On the date that this happened is the trigger for that policy to respond to cover or defend the claim or the allegation. The problem that you have with these COVID things, particularly if you have opened up your amenities, is there is no one certain date that you can point to say that I was exposed to this person or was I exposed to COVID-19 and that's how I caught it. It's going to typically happen over a period of events, unless you host a large outdoor event and a lot of people catch it. It's very difficult to determine that date certain. And the other part of it is, another hurdle, big hurdle that you have to get over is the causation, right? The causation is, what was it caused by? Is it resulting from or arising out of what actions of the association that caused me to contract COVID-19? Unless you've been living in a bubble for the last 8 months, you have gone to the grocery store, you have gone to the drugstore, you probably have ventured out and eaten outside somewhere. So to be able to say that I was exposed because I went into the gym at the association, or I went into the clubhouse, or I went to the pool, or whatever amenity I was using, and I had an exposure and that's where I caught it, is a very, very difficult hurdle to overcome. We don't have a very good tracing policy in place. We're trying to get there, but it's still very difficult. It's really important, if you did open up your pools or your amenities, that you are documenting who's coming in and who's using it and when they leave. So if there is an exposure, that you can actually go ahead and do the proper protocols and notifications. The other issue that happened, back in 2003, when we had a big SARS outbreak, and then subsequently Ebola, the insurance industry implemented CPO 1400706, which is basically the exclusion of loss due to virus or bacteria. These policies this endorsement came onto most policies starting in 2006 and have been there ever since as a result of the SARS and the Ebola outbreaks that they got. It's very clear. It's a virus. It's not going to have any defense or any coverage or from a bacteria type of exposure. More recently, and you probably have seen this now on most of your renewals, probably starting in June or July, we started to see a communicable disease exclusion that's being put on most of the package policies, umbrella policies, D&O policies, based upon or arising out of the exposure to infected individuals or animals. Predominantly most of the carriers that are providing property and liability coverage in the state of New Jersey have added these communicable disease exclusions to the policy. And it's just more of a clarification of the virus and the bacteria, just to say that this extends to a communicable disease type of exposure. Last and not least, if you're able to get through all of those other hurdles, the other big hurdle that you'd have to get by is probably the first exclusion that you're going to find in the policy when you get to the exclusion section of the policy. It's called expected or intended injury. So bodily injury, property damage, expected or intended from the standpoint of the insured. Most people, if you talk to them, understand if you open up your facilities and you allow more people to get exposure to one another, it's expected that they're going to catch or catch COVID-19. So this is another big hurdle that you would have to overcome just to trigger a defense from the general liability exclusions. If you're able to overcome all of those hurdles, then you may be able to find a defense. But I can say our experience since March has not been any of these types of claims have been provided any defense or coverage. So let's move on to the D&O policies, the directors and officers liability. And this is the most important for obviously all the volunteers and the directors, including the management companies that are out there. These are policies for wrongful acts. These are not, I was injured because of a bodily injury or a slip or property damage, a slip and fall. This is a decision that you made or that you didn't make that I didn't particularly care for. They're emotional claims. They're claims that are not driven because they were wronged and have caused injury by money or personal injury. These are claims that, again, they're acts or decisions that you're going to make or not make. And different from the liability policies, these are claims made policies. So the trigger for this policy or this type of defense is when the claim is made. So the action may have happened in March of 2020, when your policy renewed in July of 2020. The current policy was the one that will respond to these types of D&O claims because it's when the date of the claim is brought, not when it actually happened. And the biggest hurdle, particularly for the directors and officers liability, is the exclusion for bodily injury and property damage claims. And, as you can read here, exclusions applicable to all loss. They're not liable to make any payment for loss, shall have no duty to defend or pay defense expenses in connection with any claim made against the insured, based upon directly or indirectly arising out of or any way involving bodily injury or property damage. And when you're looking at property damage, you're looking at damage to tangible property, loss of use, or destruction or deterioration of any tangible property, failure to supervise, repair, and maintain tangible property. This has always been on the directors and officers liability policies. And the reason it's there is the bodily injury and property damage is typically going to have your coverage under the general liability policy. So this did not enable you to kind of double tap, get payment from the GL policy and now go after the D&O policy. This is the biggest hurdle and probably the biggest, I would say, biggest concern for most or all community associations, not just in New Jersey, but throughout the country, is this property damage exclusion on the D&O policy. It has been there forever, and it is something that we have to be aware of. So those are some of the exclusions that you're going to have to deal with on the D&O policy.
Vinnie, can I interrupt for a second and just say, even though those exclusions are there in black and white, is it recommended that if in fact one of our associations or boards got sued, that they should submit the claim anyway?
Absolutely, either on the general liability or the directors and officers liability. Let's put it through the process. I was listening to, Kevin Davis, Insurance Services is one of the larger producers for community associations, directors and officers liability programs out there through Travelers. And he had a program recently, and he was talking about since March, they've had over 400 COVID claims on their book of business. And in the big sense of things, they do thousands and thousands and thousands of community associations. That's not a big number, but there has not been many that have been able to overcome any of these allegations where they have provided a defense. So, that is bearing out as far as we're seeing with our experience, as well as what our, some of our competitors out there also providing. But if you do get a claim, absolutely submit it and let's go through the process and let the carrier make that determination. That's not ours to make a determination or the association's attorney. That's up to the carrier to do. So we would always recommend that you notify your agent and put the carriers on notice for any claim that comes out of this. We've talked about tort immunity. Some of the associations do have tort immunity already passed within their documents. They've either amended their documents at some point in time over the last 10 to 15 years, or some of the newer documents already provide tort immunity, but it only applies to unit owners and their spouses. It does not provide immunity to the children or any guests or anybody else other than the unit owners and their spouses. So it's a little bit of protection, but it's not a lot of protection, particularly if you have guests or anybody with children in the communities. Local legislative immunity protection. If one of the bills that Ed and Paul and Michelle talked about should get through, somebody's ring is going off. Will give protection to associations, but it's not going to stop all claims. Defense will still need to be provided for these types of claims, and it's not going to come, fortunately, from the D&O carriers or from the liability carriers. It should certainly reduce the number of claims, but the potential still exists. A lot of these, as Ed pointed out, have that exclusion for gross or wanton negligence or material misrepresentation of those things. So if they feel that they can pierce that gross negligence, they're still going to try and sue, and it still won't be covered by insurance. From the federal side, from the insurance that we're seeing, most of the focus is really looking at business interruption types of coverage to provide for the pandemic. And this is for restaurants and other businesses that, retail that have had to close either by the governor's mandate or they were unable to stay open through federal mandates. The business interruption is not going to have, right now, there's no coverage for business interruption or the loss of use of their facilities due to COVID because there was no physical damage to the premises. Now, there's been several hundred, if not thousands, of these types of claims that have been, and lawsuits that have been filed across the country. I will say there was one in North Carolina that hit this week where they did overrule the documentation or the exclusion of the policy, and they said it was there would be coverage under the civil authority, but that has already been appealed, and I don't expect that that's going to hold up on appeal because the language is very clear on that there was no physical damage to the property. So most of the federal legislation that we're seeing that has some traction is on some sort of pandemic type of insurance, which will be modeled after the TRIA, which is the Terrorism Risk Insurance Act, or the NFIP, which is the flood insurance program, or the crop insurance models. There's 3 or 4 different plans out there that are being talked about that do have some support from the insurance industry, but that's a long way off, and I don't think anything is going to happen within before the end of this year, or at least until we see what happens with the election next year. So what can the association do to protect against some of these claims? You need to develop, and I'm sure you already have, but make sure you have a written plan on managing an outbreak. You need to appoint your COVID ambassador. You need to determine how and who to notify of positive tests. Do not discriminate. There's a lot of talk about should we name that individual from a D&O perspective. We do not recommend you name individuals. We recommend that you notify people that they have been exposed to somebody and that they should quarantine for 2 weeks and have themselves tested. But we do not propone anybody being named specifically without their written consent that you can name them. And obviously follow all local, state, federal, and CDC guidelines, which is changing on a weekly basis, as you know. Whatever plan that you've got, you should be communicating that in writing and communicate often to the association and your membership. Whether you decide to open your amenities or close them, you should be using your reasonable business judgment, right? Fiduciary good faith, loyalty, or due care. As David said, what we're learning each month or each week from this virus is outdoor exposure is not as great as indoor exposure. When you get to indoor exposure, you're really looking at how is the air being moved, how is it being circulated, and how are you getting fresh air into those buildings. So opening up a gym indoors or some of these smaller rooms, the card rooms, the billiard rooms, et cetera, those activities, is not really recommended because it's a longer exposure of 15 minutes or more to somebody who's got or has tested positive for COVID, that you have your biggest experience and your biggest exposure to this type of a claim. So we unfortunately are not recommending that you do that, but if you decide to do that, you need to document who's coming in, how long they're being there, so you can notify them should there be an exposure that goes out. I will say I do have a few minutes. Just one other thing that you should note, that as a result of not just this, but, we've had the wildfires, we've had, 26 or 27 hurricanes or national, storms that have been hit, that are coming through with over $200 billion in damages. We are seeing, this is budget time. We are seeing a definite hardening of the marketplace. So if you are budgeting on a minimum, I would say between 5 to 10% for those with claims activities, and those that are on the coast, and those that have losses and have had some troubles with their claims over the last few years, I would be budgeting for more than 10%, 10 to 15% is what we're seeing across the board. There's been a constriction on the liability and the umbrella marketplace as a result of some of these social judgments that have been coming out. Previously, we would see a large judgment from a pool or something of around 4 or 5 million. We're starting to see much more higher claims of 25, 30, $35 million in claims that are coming out. So the umbrella marketplace has really gotten tough and shrinking from a limit capacity as well as a pricing capacity. So that's all that I have for you. Thanks, George.